since we're all across. We are going to record this session with Jeff's permission, so those who are not here can watch it later. So y'all just got that notice. Thanks, Jeff, for letting us record this. Since this session is all about asking questions, please use the panel to raise your hand and wait to be called on before you unmute yourself. Or you can, again, as always, you can chat in your questions as well, and I can read them out loud, or Jeff can keep up with them, however we want to do that. Don't forget, our next Lunch and Learn is in 2 weeks on Wednesday, March 23rd. We'll do a quick COVID update. We haven't done those in a while, but definitely want to have that open conversation now as states are opening back up, and to see kind of what the future looks like for your state, for education, for events, legislation, things like that. So 2 weeks, mark your calendar, and we'll get that COVID update. So let me read a quick bio real quick, and then we'll jump into questions. This is super quick. So Jeff Tenenbaum is one of the nation's leading nonprofit attorneys, and also is an accomplished author, lecturer, and commentator on nonprofit legal matters. As managing partner of the nationally recognized Washington, D.C.-based Tenenbaum Law Group, a 4-attorney boutique law firm focused exclusively on the legal needs of nonprofits, Jeff counsels his clients on the broad array of legal issues affecting trade and professional associations, charities, and other nonprofits. For 19 years, Jeff practiced law at the Venable, I hope I said that right, law firm, and shared his nonprofit practice for most of that time. Among numerous and other honors and awards, Jeff was the 2006 recipient of the American Bar Association's Outstanding Nonprofit Lawyer of the Year Award, and is one of only 6 lawyers in the prestigious U.S. Legal's 500 Not-for-Profit Hall of Fame. Jeff is the author of the ASEA published book, Association Tax Compliance Guide, and currently serves as chair of the American Bar Association's Trade and Professional Associations Subcommittee, and is on the ASAE Legal Advisory Council and Public Policy Committee. So today he's here to answer all of our questions. So I'm going to just throw this out there and see who wants to go first with their question. And if you don't have a question, then I will go with my question. Don't be shy. Again, raise your hand, type it in the chat if you're on the shy side, or if you're multitasking like many of us do. This is an hour for you guys to ask any and all legal questions. Fire away. Don't be shy.
I'll go. I have a quick question.
Go ahead.
I'm Kara Tanwar with the Texas Chiropractic Association. And our parliamentarian, we usually have our lobbyists in our board of directors meeting. And he said, the parliamentarian said not to do that because of financial reasons. And my thinking is all of our financial stuff is public record. You can look at our 990, our financials. Is there any reason why our lobbyists should not be part of our board of directors meetings in sort of any legal aspect?
Yeah, it's a great question, Kara. I've been dealing with this a lot recently for some reason. Most association board meetings are not open to the public and are not open to any non-board members or non-staff of the organization. But sometimes it is very common, of course, for association board meetings to have invited guests for certain parts of certain programs. As a general rule, it's not advisable to have non-board members and non-staff at every meeting. It would not be typical to have an outside lobbyist at every meeting. For multiple reasons. One is, while your 990s are public, there's a lot of financial information that's not on the 990. Right. And there's a lot of detail, there's a lot of issues, and the 990 is kind of the final presentation of your financials for the year. But there's a lot of things that go on. Basically, there's a lot of confidential information. It's not just finances, it's everything. There's a lot of confidential matters that get discussed. And if you have non-board members and non-staff, and I would include non-legal counsel as well, present, then it can cause a variety of problems. It can cause issues with respect to confidentiality, because non-board members don't owe fiduciary duties, like the duty of care, loyalty, and obedience, which includes a duty of confidentiality. Non-board members, the presence of non-board members can defeat the attorney-client privilege if you're talking about legal matters with an attorney, meaning that protection of the attorney-client privilege would no longer exist if there's even one non-board member present. There's other privileges, like there's something called the qualified privilege from defamation liability. So say you're talking about, a practitioner in the space or something else, you're saying some negative things about someone or a vendor or something like that. if it's only board members and staff and legal counsel present, even if you are saying something negative and untrue about that person or that company that harmed their reputation, as long as it stays within that group, you cannot be subject to defamation liability. But if there's a presence, again, of any single non-board member, non-staff, non-legal counsel present, it defeats that qualified privilege and that protection that goes with it. So for all of those reasons, it's just not a best practice to have non-board members like that present for the entirety of meetings. That being said, it is common, when you get to the public policy or government affairs update or portion of the meeting, to have the lobbyist report on his or her activities and what's been going on, what are the hot button issues and where do you stand and where your success is and how can the board get involved in helping. So having the lobbyist present for that portion of the meeting is completely fine and appropriate and typical. But beyond that, I would certainly not recommend that practice.
All right. Well, thank you very much. I appreciate that.
Absolutely.
Awesome. That was super helpful. Anyone else have another burning question? Don't be shy. No, I'll ask a question. I've got a couple. We're a small, which one should I start with? So we're a small association here in Kentucky. We've got just over a couple 200 members or so. So one of the questions that we had as we look to kind of restructure our finances is what are the legal obligations or things that a nonprofit can or cannot invest in? And then I might have a follow-up to that, kind of depending on how you answer it. Is there anything like, for example, that we cannot invest in as a C6 or something of that nature that may jeopardize our tax exempt status or anything?
Yeah, so it's a good question. It's a very good question. First off, from a tax exemption perspective, there's a difference between most tax exempt entities, like a tax exempt 501c6 organization, or if you had a related 501c3 foundation, which is typically going to be a public charity, versus a 501c3 private foundation. Private foundations are subject to a particular rule in the tax code that makes it a violation of the 501c3 tax exempt status to make risky investments. But in the association world, private foundations pretty much don't exist. So
Hi, Boo. Hang on.
Dawn, if you can mute your phone, perfect. From a federal tax exemption perspective, there's really no issues there. There's no kind of investments that are going to jeopardize your tax exempt status. With one maybe minor exception is that if you were not a classic kind of passive investment, like investing in stocks or mutual funds or even hedge funds or other things like that. But if you were, like investing in a limited liability company as like a member of a multi-member LLC, there's a chance that investment is a very good chance that investment is going to be treated as a joint venture and could well generate taxable unrelated business income for any earnings that you earn from that investment. Doesn't mean you can't do it. It just means that in most cases, it's going to generate taxable unrelated business income. That's really the only tax issue when it comes to investments. But beyond that, the fiduciary duty of care that board members, officers, directors, and senior staff owe to the organization requires that you act with prudence in overseeing and managing the affairs of the association. And so it's really not a tax law issue, it's a state common law issue, and also the state nonprofit, in your case, the Kentucky Nonprofit Corporation Act, which requires that board members exercise prudence and due diligence in all aspects of overseeing the affairs of your association, including when it comes to investments. And so for that reason, like I was just at a client board meeting last week in DC, where right before I went on to do some board training, the chair of their investment committee was speaking about essentially close to 2-year study they've done in making some more kind of risky direct investments and certain kind of riskier investments that have a potential huge upside, but a lot more potential downside, and kind of putting guardrails and into their investment policy and figuring out what they can and can't do. And that's the kind of thing that you would need to do if you're going to go down that path. Even if you don't have an investment committee, have the board appoint an ad hoc task force to kind of look into it and figure out what's acceptable, what's not, what's acceptable risk, And essentially what you want to do is amend your investment policy statement to allow for those sorts of investments, but to put certain guardrails on it, to require due diligence and all the rest of that, to be sure that the board's satisfying its fiduciary duty of care. Does that help?
Yes. Yeah, that's super helpful. One of the questions I know that as a follow-up to that came up in our kind of forum discussion was about endowment or perpetual funds as well. Do you, I don't know that you can recommend those, but like, would that be something good for an association to take a look at as well? Or what's your thoughts on that?
Well, when you say an endowment, that's typically not viewed as an investment vehicle. I mean, an endowment is typically a fund that an organization, typically a C3, but it could be a C6, kind of maintains and uses for a particular purpose, and often only touches none or a small part of the principal each year, things like that. But I would never heard of it in the investment context. But really, regardless of it's not about whether something's a good or bad idea for an association to invest in. It's about prudence and due diligence and making sure that it's really important that you have an investment policy statement. It's essentially, here's our rules of the road for investments. Here's what the kinds of things we can invest in. Here's our risk tolerance. Here's our mix of stocks and bonds and treasuries and everything else. And here's the ranges of those mixes. And then your investment managers follow that investment policy statement in making your investment decisions. So that process of having the board adopt an investment policy statement, making sure your investment managers are following it, having the board or an investment committee, exercise constant monitoring and due diligence, and making smart, prudent decisions about what you'll invest in. That's really what matters. And different organizations have different risk tolerances. But as long as there's something called a business judgment rule that protects board members from personal liability if they end up making a mistake, say an investment decision that causes big losses to the association, so long as they went about it with the right process. It's all about process, due diligence process. Did you ask questions? Did you do your homework? Did you, rely on outside experts to help make your decisions? Did you have an investment committee look into it and amend your investment policy statement in a prudent manner? As long as you go through all of those steps, exercise constant, oversight and vigilance and whatnot, and overseeing all of this stuff, then that'll help protect the members from personal liability risk, the board members.
For sure. Specifically with the endowment thing, they were looking at creating this endowment fund or to basically make enough and work off of the money that they were making for their operating expenses type of situation.
So they wanted to create an endowment within your organization and then figuring out what the endowment should invest in. Yeah, correct. But everything I just said still goes with that. But that's a good point, because if you wanted to create an endowment and just live off the interest, the earnings, the dividends, things like that, and not touch the principal, then you're going to have an investment policy statement for that endowment that is aggressive enough to be able to generate those sorts of earnings, but obviously not so aggressive that you risk jeopardizing the principal.
Right. Just writing things down, typing away. Cool. Appreciate that for sure. Anyone else have another question, or I can keep going on with my questions while you guys think about your questions?
I have a question.
Oh yeah, go ahead.
All right. We have had several members request that we create a either board position or a volunteer position for a chaplain.
For what?
What's that?
I couldn't hear the last word you said.
A board position or a volunteer position for a chaplain to do member outreach. We've had quite a few, obviously, members pass away recently, a lot of hardships going on. And I've done some research and I can't really find anything about a chaplain position. It would be a non-denominational position. Would you put it on your board so they're covered by the D&O insurance, or would it be a volunteer position, or is it just a horrible idea altogether? So I don't know if you have any insight on that.
First off, I've never heard of an association having a chaplain, but I'm not going to say it's a horrible idea. Not at all. What I would not recommend, though, is just putting someone on your board in order to be covered by the D&O insurance. Being a board member means you're subject to all the fiduciary duties of a board member. Presumably, in selecting board members, you're selecting them for particular skill sets and background and experience and relevance to the association. And the sole function of being a chaplain would not seem to fit with, the typical job description for a board member of an association like yours. First off, a lot of D&O policies cover, every nonprofit D&O policy is different. There's no standard form, but many of them cover volunteers as well. It's not just the name is a bit of a misnomer. Everyone I've ever seen covers officers, directors, and committee members, and many cover other volunteers as well as staff, and as well as the association itself. And usually it's kind of subsidiaries or controlled affiliates as well. So check your D&O policy. That person may well be covered. Even if not, it would probably be possible at little or no extra cost to get an endorsement, which is like an amendment to the policy to cover a volunteer like that. But I would definitely strongly recommend against putting them on the board of directors for that purpose. And, finally, just like any other position where that person is kind of serving as an agent, a representative of your association, you want to make sure that there's some written policy or document that they agree to, that governs what role they're serving on behalf of your organization, putting some guardrails on what they can do, what they can't do, making clear they don't have the ability to bind your association to anything contractually, liability-wise, or otherwise. They attest that they're going to act, appropriately, and follow any, code of conduct or anti-harassment policy that you have, things like that. It's a little bit top of mind because I'm dealing with a client where there was an allegation against, it's a religious organization, an allegation against, I'll just say the head of a religious congregation that was, alleged to have engaged in some inappropriate conduct with a congregant. And, that sort of thing can create liability risks for your association. So you want to have, a policy or an agreement or something in place that they agree to, at least sign off on, that says, I agree not to do X, Y, Z. That way, if someone acts outside of those parameters, that's going to help protect your association from any liability risks.
Great, thanks.
Cool. We had a question come in from Andrea in Colorado. She said she's in a public place where her headphones with no mic. So she said, recently had a local school board in the news that may have violated our state sunshine laws related to public meeting. Did membership organizations fall under any laws like this? Or are we simply bound to our bylaws and policies? A few of our board members where we're violating laws if 3 or more of them are on an email, call, or group text, etc.
Yeah, I get this once in a while. And sometimes we get, an association client of ours will get a request from someone kind of presuming that because it's a nonprofit organization that is subject to some state sunshine laws or federal. And short answer is, generally speaking, no, that's not the case. You're not, just because of your nonprofit corporate status or your federal tax exempt status, that does not, I've never seen a situation where that makes you subject to some kind of sunshine law. Now, in certain situations, if, there might be a hook that ties you into a law like that. Like for instance, if you get certain money from the state, and that obligation or that receipt of, state funds comes with it some obligation, to operate pursuant to some state sunshine law, that's a different issue. But that's rarely ever the case that I've rarely ever seen in the association world in particular.
Cool. Is there, if board members say the quorum is, 50% or majority or whatever, if more than the quorum, if they're in a group text, does that count as a kind of a meeting type situation? What's kind of the law?
It's a very good question, Rachel. So a short answer, in most states, the answer is no. So this is governed by the state nonprofit corporation law of the state of your incorporation. And for your associations, it's generally going to be whatever state you're located in. Presumably your organization is incorporated in that state. So in your case, the Kentucky Nonprofit Corporation Act would govern. Most of these laws are very similar. California and New York's laws are very quirky and different, but most of the states' laws are based largely on the American Bar Association's Model Nonprofit Corporation Act. And the Model Nonprofit Corporation Act has a provision that says for there to be a meeting of the board, all board members have to be able to simultaneously hear each other. That's the language that's used in the Model Act, and it's the language that's still used in most of the state nonprofit corporation statutes. So simultaneously hearing each other, in the old days meant telephone, like conference call, nowadays can obviously mean a Zoom call, because in both cases you can simultaneously hear each other, but it would not cover things like a group text. And so for purposes of a quorum, for purposes of voting, for purposes of having a meeting, period, it's got to be either a telephone or a video conference call. So the only alternative under most state laws, most of the state nonprofit corporation laws, a board can only act in two ways. One is through a duly constituted meeting, proper notice, you have a quorum, and then you take votes or whatever at the meeting. Alternatively, there's something called unanimous written consent, which means all board members vote in writing. It can be electronic in most states, and they all vote the same way, but all of them have to vote in order for it to constitute unanimous written consent. So that's the only time a board can take an official action outside of a meeting, is if it constitutes unanimous written consent. And by the way, someone just asked about California. So for this particular provision, I believe it's the same in California. There's nothing different there in California law. But for instance, in Texas, there's actually a more permissive provision in their statute. So in Texas, a board can take essentially a mail or email ballot, and it does not have to constitute, it does not have to be unanimous. You just have to have enough people voting to make it a quorum, and then whatever the majority vote is carries the day. That's a unique provision in Texas. There might be, I think there's one or two other states that have that sort of provision, but for most of them, it's either a meeting where everyone can hear each other or unanimous written consent. And your bylaws, by the way, if your bylaws say your bylaws were constructed in a way that follows the Texas construct, where you could have an email ballot that does not constitute unanimous written consent, but your state law says that's not permissible, that bylaw provision would not be valid. So, always consult your bylaws, but you also have to make sure that your bylaws are consistent with the state law. So like when we do bylaw reviews all the time for associations. And one of the things we're doing is making sure that the bylaws are fully consistent with what's in the state statute. And also you want the bylaws to very clearly lay out these two options. So everyone, you don't want to be consulting the state law all the time. You want to just be able to look to your bylaws to say, these are the two ways that a board can act.
Cool. Appreciate that. Anyone else have another question before I ask another one of my questions? I always have questions.
Oh, I can do a follow-up to that. This is Dawn.
Yeah, for sure.
In California, we use Slack to handle a lot of our proposals. And in that format, we require 100% agreement. Is that what you were saying when you said the written, agree to written, but 100%?
Yeah. If you're talking about board action, that's almost certainly why you're doing it. To make
yeah. And so if where we've come up is if we can't get 100%, can that issue be raised again in a formal board meeting and be voted on again, or does it die?
Yeah, so it's a great point, and I use that as a technique all the time. So let's say you can't get unanimous written consent because some person's just not available or whatever, they're not responding. So that will not constitute a formal legal board action. But if that's really all you need, you just wanted to make sure there's a pretty strong consensus to move forward with some particular position or action, and you don't need the formal legal board vote at that time, just move ahead with the action, whatever you're going to do, and then later at the next board meeting, have the board ratify that decision. In many cases, that's fine. There are, some rare cases where or many cases, I didn't say rare, there are some cases where you actually need a formal legal board vote, whether it's at a meeting or unanimous written consent. But if not, you can certainly take it up later. It doesn't carry forward. Someone would have to make a motion at the next meeting. So it kind of does die, but someone can bring it back up at any time. And certainly it's not generally a best practice, but boards can make decisions and have them apply retroactively as well.
I feel like I'm questioning everything now because I forget who told me. Someone is like, oh yeah, if there's an email going around, that could be considered a board meeting, or if there's, an electronic vote, that could be considered, whether it's unanimous or not. So now I'm like rethinking my time in Colorado as well. So that's cool. That's good to know. It's good to know. Anyone else have a question? Otherwise, I'll press on with mine.
Rachel, I have a question if you don't mind.
Yeah, for sure.
I'm just kind of curious. I think some state associations may have wholly owned subsidiaries. And if you have a wholly owned subsidiary that's an LLC, for example, does your liability and D&O policy and everything cover you down to that wholly owned subsidiary, or is that something where you would want to go get separate insurance?
Yeah, it's a great question, Liz. So a couple things. First off, you have to consult the terms of the policy itself. That's what's going to govern. So there's a definition in every policy of the insured, who the insured is. I was just looking at this recently, a D&O policy for a client, I think last week. And I was looking at the definition of the insured to see if it would cover their related foundation, which is a subsidiary. That term means ownership. So you're talking about like a for-profit subsidiary, either a C Corp or an LLC. And then, for nonprofits, like a related foundation, it's what I call a controlled affiliate. And there, the triggering definition of most insurance policies is that the parent entity, like your main association, has the ability to appoint at least a majority of the board members of the related foundation. So many policies will define the insured to automatically include a controlled affiliate or a subsidiary, where you, in the nonprofit context, you have the ability to appoint a majority of the directors, or in the for-profit context, where you own, majority of the ownership stake in that entity, but not always. And sometimes it only will cover a nonprofit affiliate, not a for-profit. So you need to look at the language itself. And then if it does not cover what you need it to, then it's always going to be a far better idea not to get a whole separate policy, but to get an endorsement to the policy, which you're going to have to probably pay a little extra for in the annual premium, but get an endorsement, like an amendment to the policy, to expressly cover. But what it would do is redefine the term insured to include that for-profit subsidiary.
Thank you.
Awesome. I think Sherry Ryan had a question from Alaska.
I did. I wanted to go back to the question before Liz's in regards to email and text actions. Sometimes I will say that in a smaller organization, when we have to move quickly and we don't have a planned board meeting, we will take a vote by text, but then follow it up with a formal vote at the next meeting. Is that considered kosher?
Well, I'm certainly not using kosher in the term that I, as a Jew, would think of it. But is it okay? I mean, yeah, I pretty much said this earlier, that yes, it's not a formal legal board action to do that, but it's essentially what some people call a poll, like taking a poll of the board, just getting a sense of the board, so that you basically say, okay, the board's on board with this. We're going to move ahead and do this action, decision, whatever it is. And then at the next meeting, someone makes a motion to ratify that decision. That's completely appropriate, except in the rare circumstance where that formal board vote is required before moving ahead with the action. So like, for instance, let's say you are going to change your name of the association, and to do that, you have to amend your articles of incorporation. You have to look to the articles of incorporation themselves, as well as the state nonprofit corporation statute, to see what's required in order to amend your articles. And most of the state statutes say that at a minimum, a board vote is required to amend your articles, like an actual board vote. And if you have voting members, most states say that the voting members also, in addition to the board, have to vote to amend the articles. So you wouldn't want to file the articles of amendment with the state until the board does the actual vote. Something, I'm just giving you one example, but that's not the norm. And what you're doing, it sounds completely kosher in most situations.
Thank you.
Anyone else have a question right now? All right. I will
have
ask.
a question.
Go ahead, Tracy.
Sorry. Hi.
Hi.
Hello.
I don't have any glasses on, so I'm struggling to see everybody. I'll pick them up till this afternoon, so everyone's a little blurry right now. But hi, this is Tracy from Massachusetts. I would like to know when signing documents on behalf of like my organization, which is Massachusetts Chiropractic Society, I actually sign the documents with my name, and then I put on behalf of the Massachusetts Chiropractic Society. Is that okay? Or how should we be signing documents? Example, I had this question like 2 years ago when we were signing a document for a hotel and knowing that we didn't know if we were going to be able to have an event. We have this, large ticket of, like $20,000 that we're going to need to pay if we don't have this event. And then my name is on it. And it made me worry. And I thought to myself, am I on the hook for this if we end up having to cancel this event? And, what does that look like as far as liability on myself personally, not just the organization?
Yeah, it's a great question. I actually have a real life story to go along with it too, that illustrates the importance of the question. And it's also relevant, not just in terms of personal liability risk, but for those of you who are employed by or own your own management company that manages the association, which I think is the case for some of you. It raises the issue of in a hotel contract situation, for instance, cancellation penalties or whatnot, or attrition penalties. Is the association on the hook, or is your association management company particularly potentially on the hook? And so the short answer is always do what you just described and make clear that whenever you are signing as an agent of the association. So, signing your name, on behalf of Massachusetts Chiropractic Association, I think you said was the name.
Yeah, that's exactly
that's the way to do it in every instance. I have a client, it's a big association management company that they didn't get sued, but they got deposed. And we had to go through it was a bankruptcy proceeding for the bankrupt so my client is in a management company. It managed an association. The association kind of went bankrupt. And there was a special court proceeding because the hotel out in Las Vegas, to whom they were owed a lot of money because the association kind of stiffed them on a bunch of money. The local attorney here in Virginia for the hotel subpoenaed my client, the association management company, because the contract with that hotel was signed by an employee of the management company, but they didn't sign it on behalf of the association. And so basically the hotel, which is one of the big well-known hotels out there, was trying to see if maybe they could, wrestle some money out of the management company, and they didn't quite understand the association management company model. And they didn't understand the distinction between the management company and the association. But it caused, and we were there in a whole day, essentially deposition and everything else and a lot of prep, all because the employee didn't sign the contract in the right way. So it's, in the end, we were able to get through it and got them off our backs. But it's a very good and important point for all of you. So basically, it's basic agency law. So like in first year law school, we all learn that you have principals and agents. An employee-employer relationship is a classic principal-agent relationship, but an association and an association management company can be a principal agent. And in the principal-agent relationship, the principal is liable for everything the agent does, but usually the agent themselves is not going to be held personally liable. So that's why, for instance, as an employee or as an AMC, if you're signing things in the right way, the association can be on the hook for that, but you should not be on the hook personally.
So I am signing it correctly on behalf of.
You are. Sorry for the long explanation, but
no, it's perfect. Yeah. I just want to make sure I was doing the correct things, because we did have something that happened in the past where someone bought a really large piece of equipment and didn't sign it correctly, and it created quite a bit of riff. Anyway, okay, thanks for that. Thank you for your time. I appreciate you being here today.
Sure.
Can I do a follow-up on that, Jeff?
Yeah.
So in my situation, it is within my contract what authority I have. Depending on the entity, it could be executive director, CEO. So hotel contracts would be part of it. But if I'm signing, I sign always with executive director after my name, or I sign CEO after my name. And then of course, Tennessee Chiropractic Association wouldn't be included. So obviously I don't have that authority anywhere else when I'm not acting in that role. Would that cover me enough, or do you literally have to say on behalf of?
No, that's okay. Fine. That's absolutely
cool.
Fine.
That's what I was thinking. And I heard that from an ASAE that I think you taught at many years ago. And I am grateful for that information, because I had a counterpart that represented the pharmacy group that had exactly what you're talking about, and they were no longer an employee, but they were coming for money. So it was a huge, major mess. So thanks.
Sure.
Cool. We had a question in the chat. Why should an association have a separate association management company versus the association? What are the advantages of this model?
I'm not sure I understand the question. I mean, an association, any association, but particularly with smaller associations, like state associations and local associations like yours, in terms of management, they're either managed by employees or direct employees, or they're managed by, what legally would be called an independent contractor, right? It could be, you individually, you form your own LLC or something, and the contract is between the LLC and the association to manage it, or it could be with like an association management company, which, that's just a label. It's not a legal, it doesn't have any legal meaning, but it's just a company, C Corp and LLC, typically a for-profit company that you might own or be employed by that has the management contract with the association. There are very significant differences in being an employee versus being a contractor. And generally speaking, like from your personal perspectives, it's almost always more advantageous to be an employee of the association as opposed to just being a contractor. Because when you're an employee, there's a whole host of benefits that go along with it. Like the employer has to pay the employer's share of your payroll taxes, which is 7.5% of your salary. All sorts of protections and anti-discrimination laws, Title VII Civil Rights Act, American Disabilities Act. There's all sorts of, state and local, particularly state, paid family leave, things that are available to employees. For non-exempt employees, you're subject to overtime for hours worked over 40 in a week. All sorts of protections and benefits. Many health insurance plans and retirement plans are only available to, employees who work more than a certain number of hours in a week. So just a whole host of benefits that generally make it much more advantageous for you to be an employee as opposed to a contractor. But on the other hand, let's say you were, you have an association management company and you manage several different associations, which is very common for AMCs. That construct is going to work much better for you being an AMC. And then you might actually end up being employed by the AMC as opposed to just an owner. But, every circumstance is different, and there's always going to be pros and cons and considerations to how you structure each. But generally speaking, the employee route, the direct employer route, is going to be more advantageous for you and probably less advantageous for the association because it's going to cost them more.
Yeah.
But in that situation, why would a state association create its own LLC? I understand when you're hiring a third party. For example,
it wouldn't. It wouldn't. There's no reason it would create its own LLC. Associations create LLCs for different purposes, but I've never seen it for that purpose. That would make no sense. You're right.
Okay.
Any other questions right now? Feel free to jump in, raise your hand. I'll ask a quick question. Just kind of generally, is there, I haven't kept up with this recently, it's probably horrible, but has there any been recent in the last year or so changes to UBIT or anything that associations should be aware of for upcoming tax season here?
No, there's really been nothing. I'm going to send you guys something in the chat. There have literally been virtually no developments on the UBIT front since like the mid 90s.
Okay.
Probably the last major development was when Congress codified the corporate sponsorship exception to UBIT in the tax code. I think it was 96 or something like that. And prior to that, there was a lot of developments in the area of royalties. There was a bunch of litigation between nonprofits and the IRS. One of the seminal decisions, the Sierra Club case, kind of settled a lot of the disputes about tax, the royalty exception to unrelated business income. There's really been virtually nothing beyond that, except there was I don't know, maybe about over a decade ago, the IRS came out with a ruling regarding virtual trade shows, particularly held by associations, and whether virtual trade shows were subject to the same exception from UBIT that applies for in-person conventions and trade shows, what we call the qualified convention and trade show exception. And they came out with some guidance then, I think it was like 14 years ago now, that said, basically that a virtual trade show would only be subject to the exception from UBIT if it was held in conjunction with an in-person trade show. But things have really changed in terms of technology and just practices and everything else. And so there's some real open questions about, whether that ruling is still an accurate statement of the law. So what I just put into the chat is an article of mine that I wrote last year. That version was published by the American Bar Association, but and it's on our website as well. That talks about it. Basically, I used kind of the virtual trade show pandemic stuff that was going on as a hook to update kind of my writings on the trade show exception, the corporate sponsorship exception, and the royalty exception. So they're all kind of encompassed in that one article. So it should be a good kind of refresher for you guys on those issues. And I'd encourage you to take a look at it, and I'll put the other version in there right now. And it's actually a good opportunity to remind you guys that we have a ton of resources on our firm's website, hundreds of articles and PowerPoint presentations on a whole variety of different nonprofit legal and tax issues. And I just posted a link to the kind of the index of all of those. And then we also have a ton of, especially since the pandemic, and I've been doing literally probably 150 online, like Zoom webinars for the last 2 years, most of which were recorded. We have recordings of webinars, like things like this, but lots of others on different topics on a whole variety of association and nonprofit legal issues. So I just posted the link to that as well. So anytime if you're looking for something, some background or on particular issues, look there. If you can't find it, feel free to email me. My contact information's easy to find on our website, and happy to direct you to any resources I might have. We also have, and I get requests from association execs all the time. We have they're not mainly on our website, but we have a pretty big library of model kind of association and nonprofit forms, policies, and agreements. So anytime you're looking for something, everything from independent contractor agreements to liability waivers to speaker and author agreements and kind of everything else under the sun. If you're ever looking like you need something like that, just reach out instead of trying to reinvent the wheel. And I'm happy to send you whatever we might have saved on our system.
Cool. That'd be awesome. I think Liz has a question for you. And then maybe Tracy has another one coming back.
I'm kind of curious about best practices around executive contracts and renewing them, reviewing them, and what your thoughts are as far as representation for both the executive and then the board, and what you've seen work best.
So I do extensive work with association and nonprofit executive, particularly CEO employment contracts, both sometimes representing the association, like for existing clients of mine, and often representing the individual execs as well. Literally, we work on these every single week, my 3 colleagues and myself. So, I mean, I've done entire sessions on this, and there are some resources on our website about this stuff too. But when you say best practices, Liz, can you be a little more specific what you're asking about? Because I could speak to so many aspects of this, but I want to make sure I'm getting at what you're asking about.
Yeah, I'm sure it's probably structured differently depending upon, an existing contract or whether it's a new contract coming into play and what has already been agreed to for who's paying for what. If the employee or the executive, wants their own review, are they generally always going to pay for that themselves, or is that something you build into a contract? Obviously, I would be curious about having separate legal counsel, not the same legal counsel, doing the review for each group.
Yeah, so if you're asking about that aspect of it, generally speaking, I say generally because there are some exceptions, but generally speaking, the association's legal counsel, association's legal counsel, if they're representing the association in the employment contract negotiation or drafting and whatnot, they cannot also represent you as the individual exec. That's a clear conflict of interest. But there are some rare instances where, like, I'm working with, association, they're a client of mine, I'm like their outside general counsel, and the exec wants me to represent him or her in the contract negotiation. I can do that if two things happen. A, there's a conflict of interest waiver by both sides, and B, if the association has separate legal counsel representing it in that contract negotiation. I can't be on both sides. But generally speaking, that's a rare instance. Generally speaking, the association will have different counsel than the exec. In terms of who pays for it, when I represent the exec, we always push for the association to cover legal fees, usually up to a cap. Usually I'd say $2,500 is usually the amount that we get approved. Then we don't always get it approved. Some boards and executive committees push back hard on that. Some do approve it, but it's always worth asking. It's certainly very common practice to have the association cover your legal fees up to a certain point, but sometimes we just can't get it either. They just push back hard on that.
Thank you. Perfect.
Sure.
Tracy, do you have another question?
I do. So when you were talking about earlier, the lobbyists and, having them at board meetings and things like that, I understand that. My other question is, there's always, obviously most of us have a lobbyist that's on staff, we pay them. And then also when it comes to fundraising, I'm always receiving information from our board members and also our lobbyists about new upcoming, like, Ways and Means Chair, things like that we want to support because we want them in office because we know that they support chiropractic. So, but I'm always sending these things out separately from the Mass Chiro Society so that we don't look like we are supporting a candidate, because there's always that stigma of we can't support a certain candidate because of, political campaigning and lobbying. It's like, we do it, but it's such a fine line. And how do you get around that? And am I making sense in what I'm saying?
So, a few things. First off, is the Mass Society or Association a C6, 501c6 entity?
C3.
Oh, okay. Well, that explains it. So C3s are banned from any political campaign activity, which means supporting or opposing any candidates for public office. Even a small amount of political campaign activity can jeopardize your tax exempt status.
Got it.
Number one. And that's what you're talking about, is exactly that.
Yes.
C3s are allowed to lobby, but only up to certain limits. There's two different sets of lobbying rules depending on whether you make the 501h election. I have a great article on our website that talks about all this stuff if you're interested in learning more about that. But the thing is, when you say you're sending it out separately from your association, are you talking about you doing something individually?
Yeah, so we have a legislative chair, and so he contacts me about what they would like to see put together. So I put it together and make it look all pretty, and I send it to him, and then he sends it to anyone and everyone that he can send it to in order to create these fundraising campaigns. So it kind of pulls me out of the mix of it. But, I'm always wondering, we want to support this certain candidate. We know that they're for chiropractic. It'll be good in the end.
Yeah. What you're doing is it puts your tax exempt status at risk.
Got it. Okay.
You got to stop doing it that way.
I'm not doing it and sending it out.
I know, but because you are an agent of the association, and if he's your chair, he's an agent of the association too.
Got it.
I literally just gave a board training a week or 2 weeks ago where they're C3, all the board members are very politically active. And I said, you have to be extremely careful. You can do whatever you want on your own time, personally, supporting candidates, giving, PAC contributions, going to fundraisers, all that kind of stuff. But you can't in any way tie it to the association. So for instance, if you're putting something together, you're the executive director, you send it to him, that's the association engaging in political campaign activity. He's going to do something on his own time with his own money. You should not be involved in any way. And he should never sign an email or identify himself as the, chair of the association or anything like that. It has to be a really firm dividing line. The other option, if you wanted to, and it's not uncommon, would be if you wanted to get more politically active, would be to create a separate but affiliated 501c6 or C4 organization, in your case, probably be a C6, that is a C6s are allowed to engage in political campaign activity. And a
There is
C6
another one.
can also have a political action committee, which can give campaign contributions. So that's a common model, to have an affiliated C3 and C6, where the C6 is engaging in the political activity, often the lobbying activity as well. The C3 is not. The only thing to keep in mind is that the C6 has to have independent funding. The C3 cannot subsidize, support, give money to the C6. It has to raise it on its own, but it's usually pretty easy to do, because what most groups will end up doing is, say your membership dues that are being paid to the C3, you just kind of split it up. So whatever the percentage is, say 25% is going to now go as membership dues to the C6, and the rest will go as membership dues to the C3. That's an easy way to create an independent funding stream.
We do have that, actually. We have a CPAC with a C6, and it's actually managed by another foundation. But at the end of the day, they call on me to help.
Well, but the way to deal with this would be for you to have some relationship with the C6, either as an employee or as a contractor, so that whatever time you're spending on that gets attributed to the C6 instead of getting attributed to the C3. That would be the way to deal with it.
That makes sense.
I really only have time for one more question, because I have another webinar I need to do at the top of the hour, and then I need to dial in a few minutes early. So got time for one more question.
Anyone else have a question? Otherwise, I could ask one of my other ones. I'm gonna leave it open. All right, real quick, and this may be a long answer, so I don't know if it's the best question to ask, but recently it's come up about vicarious liability and what does that look like for us as a hands-on profession, either when we have a speaker who's doing hands-on things and say a participant gets injured at the event, or the participant get injured from the adjusting itself or the hands-on thing itself. What do you know kind of about vicarious liability and recommended? I think it's something new that we're exploring as a chiropractic profession. And so just kind of wanted to get a little bit of more information on it, basically, if you know anything about it.
Yes, I do deal with these issues quite a bit, including with healthcare organizations that we work with that deal with similar issues and whatnot. So vicarious liability, by that what you're saying is essentially someone else is doing something, someone like who's not an agent of yours. So they're not an officer, director, or employee, for instance. There can be other types of agents, but those are the typical ones. So someone who's not an agent is doing something like a member giving a presentation at an in-person conference or event or something like that. And the question is, when could something they do that causes harm to someone create liability risk for your association? Generally speaking, non-agents like that are not going to create liability for your association, but it is possible. And there are certainly plenty of instances of that happening, including non-physical things like copyright infringement and defamation and other things like that from speakers at conferences and whatnot. But it's all the same basic principle. So how do you mitigate against that? A few things. A, you have some sort of an agreement with that person where they agree to abide by certain practices, certain best practices, certain guidelines, standards, whether they're coming from state licensing boards or private associations or whatever the case might be. They are representing and warranting, attesting that they're going to abide by those standards, that they're going to do X, Y, Z, they're not going to do A, B, C, all of that. You can also include a provision in there that says if your association gets sued because of something they did, that they agree to indemnify you, meaning holding you harmless, pay your legal fees, pay any judgments or settlements against you. That's one way to do it, to deal with it. Also using liability waivers. So if there's the patient, a subject of a demonstration, you can have that person sign a liability waiver that says if something happens, they realize there's some risk attached to this. And if something happens, they agree not to sue your association for that. Generally, those liability waivers are going to be enforceable and upheld so long as there's not gross negligence or willful misconduct involved. So those would be probably two off the top of my head, two important techniques for how to deal with that issue. Yeah, Lisa, you had a question?
Yeah, but I could ask of the rest of them because I know that you have a hard leave stop that you have to do.
I do need to drop off.
Yeah.
Okay, guys, great questions, and I really those are a lot of different questions, and I've been getting on other forums like this that I've done, some really interesting topics, and hope you found the answers helpful. I posted also that our article on 501c3 lobbying rules in the chat in case you're interested, Someone said, how do I get a hold of you? I will just put my firm's website address on here and you can find me there.
Awesome. I appreciate your time today. I know you got to jump, so thank you so much, and enjoy the rest of your day. And then if anyone wants to stick around and had another question, like I know Lisa's got one, we'll be here. Thanks,
Sure.
Jeff.